Good evening and welcome to this session of the live virtual classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. This is our third and last day in our inquiry into the concept of incorporation of company and matters incidental thereto. Okay. 1 second. Sorry. So, moving with this, we already saw much. We have covered much ground. In fact, if I remember right, we have covered quite a lot of ground. And almost, if I may say so, 100 odd slides we have covered. Am I correct? So now we are into alterations. We are into the concepts of alteration, right? We saw up to the doctrine of indoor. I hope we did. No, I think we saw up to the doctrine of ultra vires and we stopped there. Correct. We didn't go to doctrine of indoor management. So last class, we saw the doctrine of ultra vires. Now the doctrine of ultra vires is part of the basic fundamental principles of company law. Okay. Means ultra means beyond. Wires means powers. Ultra means beyond. Wires means powers. So ultra wires means beyond the power. Whose power? Power of the company. How is the company's power known? How do you know what the company can do? From the memorandum. In the memorandum, the object clause very clearly mentions what the company can do, and negatively, by not including it, what the company cannot do. For example, if the main objects of a company is to make electric vehicles, it cannot do real estate development. So the power of the company. So any contract it has to enter into, any agreement, etc., should be only with respect to electric vehicle. Suppose a contract is entered into with respect to infrastructure or real estate development, the company cannot be bound by it. So the idea is the shareholders of the company have given money based on the memorandum, wherein you have said you are going to do electric vehicle. Now you are going around paying money and getting into agreement for acquiring land. Now these agreements are void. The respective seller of the land cannot insist on balance payment. Also, any money received on a void agreement, as per the Contract Act, has to be refunded back. The idea is to protect the investor. The investor has to be protected, right, from the directors. So, the term ultra vires means beyond the powers, whereas the opposite is intra vires, meaning within the powers. Now, when a company or directors violate the provisions of this act or any other law, such an act is unlawful and attracts penal liability. Such an act cannot be ratified even with the consent of all the members. Boss, the Companies Act, you can't, all the members cannot pass a resolution, let us violate that act. No. Okay, because we already saw the memorandum is subservient to the articles, and the articles is subservient to the act to override memorandum, memorandum to override articles. So you cannot override the act or do something that is criminal or unlawful. Suppose the directors exceed their authority, be careful even then. If it is something that is violation of the law, for example, the directors have not deducted TDS and paid to the government. This is a violation. This is a prosecutable offense. Now the shareholders cannot ratify it and say it's okay if you've not done it. We will pardon you. Who are they to pardon? It is the government which has to pardon, which it cannot do except in some rare cases. Okay. So but other than criminal and other than unlawful acts, so long as the directors have acted within the scope of the memorandum, so long as the directors have acted within the scope of the memorandum, but beyond their authority, then the company may ratify what the directors have done. You able to understand? I'll give one simple example, easy to understand. Later on in indoor management, you will understand it. Simple example. As per the articles of association, directors can borrow only up to 1 crore on their own power, 1 crore. If they want to borrow beyond 1 crore, they have to get resolution by the members. They have to hold a meeting. Later on, when you come to management and administration, these words will be explained to you. Right now, I'll be using them. Resolution means decision taken by the members through a majority vote. Resolution means a decision taken by the members through majority vote. Right? Now, such a resolution should be passed for above 1 crore. Now, what the directors have done, they have borrowed 5 crores, more than 1 crore, but without getting the special resolution. So clearly, the directors have exceeded their authority as laid down in the articles. But the purpose for which they have borrowed is for the company within the memorandum object class. Are you able to understand? For the purpose of, maybe they borrowed for working capital need. Urgently they needed, the MD decided, the board met, they decided and done. Though the article says they didn't have time for holding whatever justification. They have definitely exceeded their authority. Now, they can always go back to the company, call a meeting, and inform the company that the shareholders, boss, we needed money. This company, we could not have paid the salary and all. Therefore, we borrowed 5 crore. But as per article, we can borrow only 1 crore. Now we have exceeded our authority. Kindly ratify. Members can ratify. They will ratify because after all, they are done only in the interest of the company. Ratify. In case some of you have problem with the word ratify, again, let me clarify. Ratify means after something is done, approve. See, before doing, if you go, it is permission. After doing you to go, it is ratification or approval only. Are you able to understand what I'm saying? You want to marry somebody, you don't tell your parents, you get married, then you go and meet. You tell your parents, I got married. This, what they can do? Can they give permission? No, they can only ratify. Okay, whatever you have done, we accept it. Are you able to understand ratification? So approval after the event. After the event, you approve it. That is called, before the event, it is permission. Papa, I'm decided to marry so-and-so. Now, please permit me. Okay, we permit you. There is permission. Before permission. Before, then it is permission. Baad, ratification. You have done it. Now you are coming. What to do? Ratify. But the company can refuse to ratify, in which case the directors will become personally liable. Be careful. That is why, as directors, never exceed your authority. Do it at your own risk. Because if the company refuses to accept it, then it is a violation. Of course, it's a big issue. That is when indoor management will come. We'll see. That is when indoor management will come. Okay. Right. Now, act which is beyond the scope of memorandum of association is ultra vires. Act which is beyond the scope of the memorandum of association is ultra vires and therefore void. Void ab initio. If some of you are not aware of what is ab initio, it means from the beginning. Beginning. Aram se, from the beginning. Right? From the beginning. This view is laid down by a famous House of Lords decisions in Ashbury Rail Carriage Company Limited versus Rish. Very famous decision. If you know this, if you can remember this case law, it will be nice. Correct. Mr. Brahmpal from the northern region, Brahmpal gives a nice Latin term for this. I was trying to use simple English, Asan English, to help people to understand. Our man is using extremely complicated Latin, but he's correct. He said ex post facto approval. Absolutely. Ex post facto. Wow. This is another extraordinarily good Latin term. Facto means fact or event. Facto is event. Whatever happened is factum. Post means after. Ex post means after the event is over, you approve it. Ex post facto approval. Absolutely. Ratification is ex. Beautiful, Mr. Brampal. I'm so happy that you're learning Latin maxims. Those ex post facto approval. Yes. Ratification is after the event is over, you approve. Fantastic. So ab initio means ab initio. From the initio, you can understand. Beginning, initiation, starting. So initio, initially he came. Thereafter he started shouting. So that is initio, ab initio. So Ashbury Rail Carriage Company Limited versus Rish. Now you might think, what is this? Sir, I am a third party. I enter into a contract with the company. You are saying because it is beyond the scope of the memorandum, the contract is void. I am suffering. But it is not meant to protect the third party. It is meant to protect the investor. Because money has been given for the purpose of the purpose stated in the memorandum. I believe. So when I saw the memorandum, I read EV, electric vehicle. I'm a green energy person. I believe I support the government and I feel that green energy is needed. Therefore, I'm investing in this company. Now, suddenly the directors have entered into agreement for purchasing land. And for that, they have paid advance. No, my money cannot be used for this. One. Two, based on the EV project, a bank could have lent 200 crores. Now, they are looking to the project for the repayment. Now, you can't take the money and invest it in some, or agree to invest it in some unconnected industry. So, the creditors also are being protected because the fund to which they must look for repayment is not dissipated in unauthorized activities, right? Now, you can always justify and say, boss, better EV, this is more profitable than EV. Agreed. Then why in the first instance you didn't have that object? Those who wanted to make money through real estate would have invested in you. I didn't invest for that. We will see this when we come to alteration of memorandum. We will see what happens. Because you can always amend your memorandum. I'll show you how it's be done. Little bit later, I will tell you how memorandum should be altered. Memorandum can be changed, altered, modified. There is a procedure for that. You go through that, change it, and then enter into the agreement. This is very, very important, which is why, friends, most banks, when they lend money to you, first they will ask you, they will, of course, go through the memorandum, etc. And then they will ask you to confirm that this is within the object class and that this money will be used only for the memorandum main objects. Then only they'll release the money. That assurance will be given. Thereafter, you use it for some other purpose. No, but your assurance will be given. Only then they will lend. In case you use it, then the directors are criminally liable for defalcation because you have no business using it there. Today, banks are becoming very, very tough on diversion because the RBI is also becoming very tough on diversion. Diversion means when one route you're going, suddenly you go left route. See, no. Money which is given to the company for a project should be used only in that project. It should not be diverted to group companies. It should not be diverted to unrelated activities. Banks are also very particular. One more thing is the rationale behind the doctrine of ultra vires is competency to enter into a contract. Friends, for an individual like you and I, competency is determined by age or soundness of mind. So, should have attained the age of majority and should be of sound mind. This is the criteria Macaulay gives for individual competency and should not be an insolvent. Okay? Should not be an insolvent. This is the condition he says. Now, for company, minority doesn't arise. Unsoundness because there is no mind there. Insolvency may come, but that by the time if it becomes insolvent, it will be out. IBC will come and that's it. But a company's competency is decided by its object clause or charter. Whatever is stated in the main objects is what the company is competent to do. Are you able to understand? Now, when I was born, no charter was prepared. My parents didn't file. We hereby confirm that the child born would become a member of the Institute of Chartered Accountants. Nobody can give that type of information. If only they can give, they'll be more than happy. If only parents are given this option, I'm sorry to say this, but it's a fact. If your mother and father are told, now itself you register before, so that we will ensure that the child born will automatically become doctor, engineer, chartered. Now you can choose. Most parents would willingly go and pay money and take it. They want that certainty. Today, that's what they want. When parents take their child to a coaching center, they don't mind spending 6 lakhs, 7 lakhs on the assurance. Your son will become CA, your daughter will become CA, like that. That assurance they want. If only somebody can give that assurance at the time of birth, imagine how much money they can make. Okay? Sorry, such things are not possible. And those people who say that they can make you a CA without your effort are liars. Okay? Your effort is needed. Support can be given by teachers and gurus like us. We can give you support, we can give you input, we can give you awareness, understanding, so many things we can give. But we cannot make you. And that too, after taking money, never. If such promises are made, they are done by frauds. Never believe such promises. Okay? Believe in yourself. That is easier and that is better. So, that is what I said. So, no individual will have a memorandum. Though, of course, when you are a little bit more mature, 18 or 19, you can prepare a mission statement. For example, I prepare a mission statement once in every 10 years. I prepare a mission statement and means I decide what I would like to do in the next 10 years. By the end of the next 10 years, I give myself milestone events that should have occurred. Now in the fourth decade of my fourth mission statement is now going. Like from 1997 to 1999 to 2009, 2019. Now the 2029 is going. Okay. So 99 was the first, then 2009, then 2019, now 2029. Yeah, inshallah. Okay, nobody can tell. I've just started it now. So 2019, we started it. So of course, the mission will change. The goals will change. The goals should change. Okay, so point I'm making, sorry for all this unnecessary stuff, but think about it. Okay, we can decide what such a broad mission and a vision. Yes, people who have a vision and mission achieve it. We have our own examples, like our past president of our institute, CATN Manohar and Padma Shri. CATN Manohar is a classic example of vision and mission, of clarity of vision and mission and ability to achieve whatever he wants to do in his life, he has achieved. So it is possible. You should take your inspiration from such role models. Okay, you should go through the story. In fact, many of us across the country are requesting him to write his life story, autobiography. Most probably he will publish it. If so, it's a great boon. When the book comes, you should take it and read it. And how he decided what he used to. I have met him, right from the time I started my practice, roughly around 1990s, to now I know him. On and off, on and off. I never failed to be impressed by his clarity, by how he. It's a different thing. I don't want to waste your time, but think about it. There are people who do this, who fix a vision and mission, and who plan in our own institute. I'm not talking about my MS Dhoni, or I'm not talking about some big shot cricketer. I'm talking about our own past president of our institute, the living role model, right? So, but unfortunately, company cannot do all these things. So the only thing I can look to is the memorandum of company, where affirmatively it states what the company can do, and by not stating negatively what the company cannot do. Okay. So the rule is very clear. The corporate life cannot be spent for any purpose other than those specified in the memorandum. This is Ashbury Rail Carriage Company versus Rish. That is the idea of the doctrine of ultra bias. To understand, so this is basically what does it mean? Any contract entered into which is beyond the scope of the memorandum is void ab initio. Okay. Of course, the third party will suffer. See, in this case itself, what happened? This Ashbury Rail Carriage Company was supposed to manufacture railway carriages. Right, that's about it. The memorandum was clear. They want to manufacture rail carriages. But they saw one nice opportunity, side opportunity, by which they got an opportunity to lay tracks, railway tracks. They had the competency, but the memorandum was not mentioning. So they had the opportunity for laying a railway line in Belgium. So this company took up that contract, and for that purpose, they ordered coal. Other things on contract, they ordered and supplied. Now the coal wala came and said, give me money. But by then the company had gone into insolvency. So the liquidator said, I won't pay you. That is how the case goes. And the coal wala goes to court, then it goes to Court of Appeal. And finally, Ashbury Rail Carriage Company goes to House of Lords. And where Lord Macnaghten very clearly says, sorry, what to do, brother. The object class is clear. It's only for manufacturing rail carriage. Who should have taken care? The court was very clear. You, the third party, should have seen the memorandum. Why? This brings us to the doctrine of constructive notice. See, the third party will ask, how will I know? How will I know what is there in the memorandum? Your Honor, your Lordships. How will I know? You will know, because when this company filed the memorandum, the time when this company uploaded the memorandum in the MCA website, or in those days, no MCA website, it would have been filed with the, the Register of Companies in England. It became a public document. Okay. So before you can understand this, you should understand the doctrine of constructive notice. Before you can go to indoor management, you should understand constructive notice. We've already mentioned this to you once. If you remember, when the memorandum and articles were filed with the Ministry of Corporate Affairs, they became public documents. In fact, every document which is uploaded in the MCA website officially is a public document available to the public, with a few exceptions. Certain documents are inspected only by members, certain can be inspected by all. So that there are certain inspection criteria, but most of the documents which are necessary for a third party are available for public viewing. For example, register of members, you can see. Articles, memorandum, you can see. Charges, later on you will be studying registration of charges. Any charge registered. So any property offered as security, you will be able to find out. So all this is public documents that you can verify. If so, there is an automatic rule of presumption. Means what? Even if you have not seen the document, it will be deemed, presumed that you have seen it. So it is a rule of presumption. Constructive means deemed. Notice means knowledge. So constructive notice means deemed knowledge. Even though you might not have seen the memorandum, it is presumed, it is deemed that you have read and understood. So the doctrine of constructive notice is a rule of presumption that a third party proposing to deal with the company has read all the documents filed with the ROC. Not only read, he has also understood it. Therefore, he is expected to know what the company can and cannot do. This being the case, if without seeing the memorandum, a fellow enters into a contract, tomorrow you cannot say, how will I know, sir, how will I know? You are deemed to know. So this is called doctrine of constructive notice. He cannot later plead ignorance. Agreed. Now, I will finish this and then take up questions. See, there are two ways of raising questions. One is the query pad. The other is the chat box. I humbly suggest that we'll have only one way of asking question, which is the query pad. Please do not raise any questions in the chat box. Try to avoid. You can access the query pad, and for your information, I have uploaded this PowerPoint presentation in PDF format in the Institute portal. This entire PPT, which as many of you have been asking me, I'm sure now also somebody might have put it in the chat box. When will you upload? Sir, when will you upload the PPT? Aaj to kar diya. I have done it. It has been uploaded along with two assignments I have uploaded, which I, inshallah, hope to do today. Okay, which I hope to do today, which I want to discuss today with you all. So, therefore, he is expected to know what the company. Now, constructive notice is fine, sir. you are deemed to know, that, okay, but how can I know certain things? For example, in our example, we said, as per the articles, the directors can borrow up to 1 crore. Beyond 1 crore, they have to get resolution or decision from the members. Now, when you read the articles, you are reading the substantive portion. You are reading the substantive nature of the transaction. You are not aware. You are a third party. You have read the articles. So, doctrine of constructive notice, why constructive? You have actual knowledge. You have read it. And you have seen the article also. Very clearly, it says, for directors have to obtain a resolution, ordinary resolution for borrowing in excess of 1 crore. Simple majority. What you can do now? You call the directors, or you send a mail to them asking, we find from articles number so-and-so, clause number so-and-so that this is, you have to do it. Kindly confirm whether you have done it. Are you able to understand? Now, there is a procedural part, Baba. They should hold a meeting, and that they should hold a meeting, pass the result, blah, blah. All that. It's a procedural part. I know the procedure also. So immediately what I send, one more mail, dear company, in case you pass the resolution, kindly send me the resolution copy. So they send you a scanned image purporting to be an extract from or true copy from the minutes of the annual extraordinary general meeting of Dubakur Limited. Clearly, they resolve that. In pursuance of clause 54 of the Articles of Association and the provisions of the Companies Act 2013, the directors be and are hereby permitted to borrow in excess of rupees 1 crore for any amount or up to an amount of rupees 20 crore for the purpose of the business of the company. Signed, Chairman. That is again countersigned by the MD or director saying true copy. Beautifully scanned. Mailed. I got it, put it in my file. Now, sir, how do I know whether that meeting was actually held, sir? How do I know whether the resolution was actually passed? I don't know. I can't know. I'm not God. Are you able to understand? An outsider may be presumed to have knowledge of both substantive and procedural aspect. Baba, I know from your articles that you have to pass a resolution beyond 1 crore. I also know that to pass a resolution, you have to hold a meeting, blah, blah. I have asked you, have you passed a resolution? Yes. Have you held a meeting and passed the resolution? Yes. Can you give me proof? Yeah. Take it. Now, law. Now what happens? I have everything. No. If you come back and say later on, when I file a suit, you come and say, the liquidator comes and says, no, that meeting was never held. Those were fraudulent fellows. They never held the meeting. They simply sent a forged resolution to the bank. Not my problem. Not my problem. How can I find out whether a procedure has been actually complied with? I cannot. The doctrine of indoor management protects me. I can presume in my own favor that things which ought to have been regularly have been done regularly. This is known as the doctrine of indoor management. In this sense, the doctrine of indoor management is an exception of the doctrine of constructive notice. The doctrine of constructive notice is a rule of presumption in favor of the company against the third party that he has deemed to be aware of what is stated. He cannot later on plead ignorance. Okay. So the doctrine of constructive notice protects the company against the third party. The doctrine of indoor management protects the third party against the company. Because if something has not been done, but it is told that it has been done, third party is protected. So now, why is it sometimes called, in the books also, if you see in the institute material also, you'll find it is called Turkan's rule. Royal British Bank versus Turkan. See, friends, I don't think our institute in future is going to ask you a question which is like this. Briefly discuss the briefly discuss Turkan's rule and its notable exceptions. Sorry. Such a question can never be asked in the examination. On the other hand, they might give you a situation and ask you to give a solution. 4 marks, 3 marks, 10. Be prepared for that. This is the pattern in the exam. Never will they ask you an outright theory. Rarely. Maybe such questions will be hardly 20-25% of the total marks. Rare. If I want to test you on doctrine of indoor management, I will give you an example. See, for example, I'll tell you, a company had powers to borrow money, provided a proper resolution was passed. The company borrowed money and issued bonds. The resolution was not, in fact, passed. It was held that the company was bound. See, the company borrowed money and issued bonds, that is, they issued debentures. But the resolution was not, in fact, passed. Sorry, I am the third party. The fact, I can only find out, did you pass? You say yes. Then what can I do? The fact that the resolution was not passed. See, the bank was bound to inspect the articles, which it did. And they knew that there is a need for a resolution. We asked you, did you pass it? You said yes. Maybe we even took a copy. You gave me a forged document. I put it, or without even passing. See, this happens a lot. And many companies, they simply don't have meetings. Instead, when this type of a thing comes, the company secretary will prepare one extract like what I told, and then get it signed and send it. If he's a smart company secretary, he will prepare minutes also. But sometimes, these people won't pay the company secretary his fees. So after 6 months, that fellow will go away without completing the minutes. That's it. Now, that is not our problem. I'm the bank. I asked you, have you? Yes, you said you have. Then I am not bound to inspect. I'm bound to inspect the articles I did. Beyond that, I'm not bound to look. Because if I do that, it would take me indoor, behind the closed doors of the company's boardroom. I don't know what happened in your boardroom, whether you call that meeting. I don't know what happened in your general meeting, because I'm a stranger. The similar view was also decided in another case law, Mahoney versus East Holliford Mining Company Limited. Mahoney versus East Holliford Mining Company Limited. Are you able to understand? Similar. But the word indoor was used in Mahoney. Mahoney's case, the word indoor was used, where the House of Lords very clearly said that would take him indoor. Similar case, where the directors could borrow up to a limit. Beyond that, they cannot borrow. They borrowed, but the resolution was not passed. Therefore, the transaction was invalid as per the articles. But the bank which had lent money need not bother, because I have done my due diligence. You not done it, it's not my problem. You have to pay my pay. The company was bound to repay. Similar decision, but in that decision, the House of Lords went on to say, if they look beyond the articles, or if they look beyond the public document, it would take them indoor. This word was used in this case. Now, obviously, in fact, I made this point in my lectures at the Bharatidasan Institute of Management, where I offer a course on law. This semester, I'm offering a course on law. I was teaching them something, sale of goods, nemo dat quad non abet, or something like that. When I told them, boss, law is nothing but exceptions. Knowledge of law is not about knowledge of what can be done, but if what cannot be done, but what are the exceptions to that rule? So most of the time, law is knowing the exceptions. Because think about it. If you tell the law, the client won't come to you. He can read it from the book, or WhatsApp is there, social media, he can learn so much. Why does he need a chartered accountant? He comes to you because you have in-depth knowledge. That in-depth knowledge means you know the smaller factual situations where you can interpret and you can say, this won't apply to you, sir, because you are satisfying these criteria, like that. So whenever you learn a law, whenever you learn a rule, you should also verify whether there are any exceptions. See, later on, when you come to share capital and debentures, they will tell you the company cannot issue shares at a discount. Prohibition. They will also give you two exceptions. Two notable exceptions are there. So you should know what the exceptions are, because questions in the exam will not be on the rule, they'll be on the exception. They will find out whether you know the exception or not. That's the point. Are you able to understand? So there are some notable exceptions to the doctrine of indoor management. One, persons purporting to act as directors. Let us look at that first. Persons purporting to act as directors. Okay. Are you able to understand what I'm saying? Now, the example I have to give, you will understand it better. This was decided in Howard versus Patent Ivory Company Limited. If you want, I will write it on the board. The case law for this, Howard versus Patent Ivory Dant है ना, हाथी का दांत, Ivory Company Limited. Okay. So Howard versus Patent Ivory Company Limited. In that case, what happened now? The articles of the company, numbers are not important here. It can be anything. That the case law, there may be different number. I remember same Vim, there are some advocates also in that group. I was talking about in Contract Act, the famous, what is that? Fundamental case, yeah. That is social obligation. Like, so at that time, I was saying something about it, that case law, when I said, what is that case law? Somebody versus somebody. So suddenly it's skipping my memory. So, and I said so and so, that lady, she was getting into the ship in Burma and waving to her husband when this guy said, I'll pay you 100 pounds, darling, I'll pay you 30 pounds every month, darling. Okay. So, but basically, that actually happened in Burma, not in, no, it happened in Sri Lanka, not in Burma. So, boss, the British were everywhere here. They were in Myanmar, they were in Sri Lanka, they were in India, they were everywhere. So, but the case law, it so happens, was in Sri Lanka. And they knew it. So, I don't know. So they said, sir, it's not Burma, sir, it's Sri Lanka, sir. Okay. The case law will not change, if it changes, the location changes. I said Burma, it is Sri Lanka. But then, what is the principle involved? Is the one. Okay. So, in this case, let us say, for example, up to 2,000 pounds, directors can borrow. Beyond 2,000 pounds, directors cannot borrow. This is a fact. Okay. Now, please note it, Your Honor. The directors themselves lent 5,000 pounds without passing a resolution. Who lent? Directors themselves. Are you able to understand? Now, you are the directors. You are the directors. You knew that there is an irregularity. Am I correct? You knew that there is an irregularity. This is actual knowledge of irregularity. Purporting to act as director, I'll come to it. Purporting to act as director is a slightly different example. So, persons having actual knowledge of irregularity. No, you are the director. You know the articles. You are the people running the company. You know that up to 2,500 only you can lend. Now, knowingly you lend 5,000, then how can you say that you are protected by the doctrine of indoor management? Indoor management is meant for a third party who cannot come inside the boardroom. Because you are very much in the boardroom. You are indoor. So can you say, doctrine of indoor management will apply to me, I cannot go indoor. You are indoor. You knew it was being violated. You had knowledge of the irregularity. How can you say, I'm protected? So that is the first exception. People who are having actual knowledge of irregularity, no. Next, that is persons purporting to act as if. That is in Morris. You can write this down somewhere. It is there in the institute material also, I'm sure. But you can also write this down. Morris versus Cancer. Morris versus Cancer. Where very clearly, persons purporting to act as director. See, what happened was, A, who ceased to be a director, B, who was never a director. A ceased to be a director. B was never a director. Okay. Two gentlemen, they come together and have a board meeting and appoint M as a director. See, A ceased to be a director. B was never a director. These two fellows, they had a board meeting of that company. And in that meeting, this fellow M also comes and they make M a director at that meeting. And together, these three donkeys allot shares to M. In that board meeting, they allot shares to M. Now, later on, The liquidator, as usual, questions it and he says, why should I pay M? Because M is not a shareholder because it is an illegal transaction. There was no, these two fellows had no right to allot the share. So you are not a shareholder. I don't owe you anything. As a shareholder, qua-shareholder, I don't owe you. So the point, the M says, no. You're a third party. I'm protected by doctrine of indoor management. Then the court asked, brother, you are saying you're a third party. In this transaction, are you a third party? You purported to act as a director, Baba. You are not a third party. See, there's a slight difference between knowledge of irregularity and purporting to act as director. In Howard versus Patent, they were the directors, and they were doing something which was not in accordance with the articles, knowingly. So they are not protected. In Morris versus Canson, they had no right to do what they were doing. Plus, the guy who claims to be a third party was also purporting, means acting as a director. They're saying purporting to act because he cannot act as a director because he's not a director. Acting as if he is a director. Purporting to act means as if he is a director. That fellow cannot come and plead doctrine of indoor management. See, the doctrine of indoor management is meant to protect genuine third parties who truly could not have had access to the inner working of the company. Only such people can claim doctrine of indoor. And that too, they should have inquired, etc. Where the act then is ultra vires the company itself. This is actually not an exception. This is only redefinition. See, after all, if the act is ultra vires the company itself, even the company cannot ratify it. Are you able to understand what I'm saying? So, the third party cannot say, I'm not aware of it like that. Even if you are not aware, it is ultra vires the company. It is wide ab initio. You go back to your doctrine of ultra vires. Okay. So you should have, you are aware, no. Are you aware? Are you not aware of the law? Can these people do it? Knowing that it is ultra vires, how can you say that you are protected? So you read the memorandum. Basically, this is nothing but the doctrine of ultra vires itself is being given here again. That's all. Forgery. Okay. This is a classic point. Sir, if your signature is forged and sent to the bank, your signature is forged and sent to the bank, it is the bank's duty to discover the forgery and refuse to give the payment. They are supposed to be good at it. So, later on, having passed a forged check, bank cannot plead a doctrine of indoor management because the forgery is a nullity in law. Forgery is a nullity in law. There is a case law for this also, which I will try to give you. Reuben versus Great Fingal Mining Company, I think. Reuben versus Great Fingal Mining Company. That is a forgery. So forgery is a nullity in law. Lastly, where the persons are put on inquiry. See, the transactions are so irregular that a man of ordinary prudence will ask questions. For example, the MD of a company daily filed, he used to bring checks in the name of the company, endorsed in his favor. See, he will turn the check, put sign for Dubacor Limited, MD, sign. He will sign. And he'll deposit it in his account. No, once in a while, okay. But this cannot be a continuous practice now. So the bank should have immediately asked, why are you doing this? You should deposit in the company's account. Why are you putting in your account? There are people who are put on inquiry. People who should make a diligent questioning as to what the transaction is all about. Not having done that, they cannot plead doctrine of indoor management. This was decided in A.L. Underwood. A.L. Underwood versus Bank of Liverpool. Bank of Liverpool. Not Deadpool, Liverpool. Bank of Liverpool. I've given you 4 case laws. Howard versus Patent Avery, Morris versus Canson, Reuben versus Great Fingal Mining Company, and A.L. Underwood versus Bank of Liverpool. For acts done is ultra vires, the company itself is basically go back to the doctrine of ultra vires. For the Raspberry Rail Carriage versus each itself is a case law. Okay. So, in case you are given, what they will do is they'll give you one of these facts and they will ask you to find it. So, in all these cases, look for the similarities and write. This is what I would humbly suggest. Now we have to move on to alteration. Before that, let me see if any questions have been asked in the chat, because there are no questions in the, I could not see any question in this query pad. There are. Ms. Kushi Shukla is saying I'm trying to join and all, but I don't know. Balfour versus Balfour. Super, Supriya. Thank you. Balfour versus, oh, you're all brilliant students, I say. I don't know. Seriously, Balfour versus Balfour. Exactly. Wow. In Balfour versus, see, Buddha ho gaya now. That suddenly that term missing. Balfour versus Balfour. Great. So, if company has entered into ultra-wires transaction and outsider is not aware of it, then it is doctrine of independence. No. Madam, that is this exception. Are you able to understand? Where the act is done ultra-wires the company, that is that is exactly why. Now I understand why this exception is given. If it is an act which is ultra-wires the company, then all the shareholders cannot approve it. Therefore, third party cannot claim doctrine of indoor management to protect himself from the doctrine of ultra-wires. I will repeat. Third party cannot claim doctrine of indoor management to protect himself from doctrine of ultra-wires. 1. 2. That is why doctrine of constructive notice. You should know what is possible, what is not possible. You had an opportunity to inspect. For able to understand, this will not take you indoor. All you need to do is to verify the memorandum, which you have not done. So, doctrine of indoor management cannot protect you. As you rightly say, doctrine of ultra-wires, once it applies, where it is ultra-wires, the company beyond the memorandum, it is void. Therefore, third party is not going to get any benefit. Whatever he's got, he has to return it back. Contract is void. That is all. Okay. Miss P, I hope you are clear. I think I don't get your full name there. It only says Miss P. Maybe that's your initial. So I don't know what your name is. See, Srivalli Quadragunda is I'm trying to admit him. Every time he comes, I'm admitting him. Similarly, Kushi Shukla, I'm trying to admit. What can I do? I can only admit you. Not I'm admitting you to the meeting. What to do? If there is any help desk, you kindly talk to them and find out what is wrong and get in. So to answer your question, if the act is ultra-wires, see, if the company has entered into an ultra-wires, no, be careful. Suppose on an ultra-wires transaction, the company has borrowed money. The directors have borrowed money on behalf of the company. Then, be careful. It is not that the company need not repay the amount. If the company has utilized that amount, it has to repay whatever it has borrowed. But interest cannot be claimed. And case cannot be filed against the company. Whatever money was originally paid by the bank will have to be repaid. Are you able to understand? But the contract cannot be enforced. The contract cannot be enforced. Is the point. I'm sorry. Yeah, see, if they've given any money, that has to be repaid. But future money cannot be paid out of this. In fact, technically, what will happen then is the company will have to pay and collect it from the directors who are at fault. You'll have to sue the directors and collect it because the directors are at fault here. So these are very, very ticklish things. But basically, the contract cannot be enforced. The contract cannot be enforced on the company. No. In fact, bank cannot file a suit. At best, what the bank can do is they cannot sue the company. Company will not pay. It will say that it's ultra-wise, but the money actually taken by it has used it. Now it will be if the money, see, that's where, going beyond the law of contract and company law, there's a law of equity. Any money received under a void agreement should be returned back. That is not contractual. That is a quasi-contractual. That obligation will be there to refund. But that is not arising out of the contract. Please understand. The suit cannot be filed to recover the money. But if money has been received under a void agreement and used, that money has to be repaid. That obligation arises. See, we are only unnecessarily complicating this point, but if you are aware of Contract Act, you will understand what I'm saying. There is a quasi-contractual obligation under Section 62 to repay. But at no cost, the company can be sued to recover the money. No. Maybe they can be sued under 62 for only the money, nothing else. The contract cannot be enforced. Interest cannot be claimed. Money paid can be taken back. And of course, the company, if it pays the money, has every right to sue the directors and get the money from the directors. Right? It's an interesting question, but this is the best answer I can give. I hope I have answered your question, madam. Can you please confirm it to me that your question has been answered? I will try to speak louder because somebody says audio is not good like that. Doctrine of ultra vires and indoor management. Good question, very fundamental question. Doctrine of ultra vires is if I cannot differentiate. Doctrine of ultra vires is where the contract is beyond the scope of the memorandum, then the contract is void. So you are a third party. If you enter into a contract with the company, then if the contract is not in accordance with the memorandum, the contract is void. Now that is the root doctrine. For that, we say, how will the third party know? He has to go and see the public records. That is the second level doctrine. Now, the doctrine of indoor management is an exception to the doctrine of constructive notice, not to ultra vires. Doctrine of indoor management is not an exception to ultra vires. Ultra vires is there. If it is ultra vires, it is void. That's it. And no third party. But doctrine of indoor management is an exception to the doctrine of constructive notice. How will the third party know? By seeing the articles memorandum. But if he has already seen it, he cannot be presumed to know what it is that should have been done. That is beyond, it will go indoor. So that is, so doctrine of ultra vires is a fundamental doctrine. Whereas doctrine of indoor management is a protection to the third party. Okay. Where the third party has read the documents, read the memorandum and articles, etc., and ensured that whatever is being done is within the memorandum, then any purely procedural matters, he can presume that it has actually been done. He cannot go beyond that. That is a doctrine. I can't exactly say this is apple, this is orange here. There are three levels of understanding. It is not that indoor management is opposite of ultra vires or something. Indoor management is an exception to constructive notice. Constructive notice is there to ensure that public documents, nobody can say that they have not read, they are deemed to have read. So that later on to defeat ultra vires, you cannot say, I'm not aware. You cannot be not aware. That is constructive notice. You can be aware of substantive, but you cannot be aware of whether that procedure has actually been done. That is indoor management. Clear. So this is the best explanation I can give, given it. So this is how we have to understand. Thank you, Mr. Prem Kumar. Thank you for your kind acceptance. Once again. Why I laughed, you know. I was expecting this comment and Prem Kumar, then Garg wants me to upload the notes. Kar diya, bhai sahab, kar diya. I have done it. I have done it. First time I am able to very boldly say, I have done it. Okay? Because usually I will not have time to upload. Then students will keep on pressuring, oh, do it. And finally I'll do it. Today, aaj I have done it. Okay? Aaj kar diya, abhi kar diya. No postponing. Okay. You also don't postpone, you study. Okay. So forgery. See, some students, not Mr. Garg. Garg, I'm sure will, Mr. or Miss Garg. Oh, okay, I'm sure they are very sincere student. But many students, as if that notes comes, they will get. Okay, but of course, keep it safely. My suggestion: create folder, open a folder for law, keep it in there. This can be a last-minute revision for you. My PowerPoint presentation are ideal for last minute. Means last minute, not tomorrow morning exam today. No, 3 days before the exam. If you want to revise law, quickly you can go through my notes. You should read the institute material once, then last minute, quickly, check. For that, they are very useful. Keep it in your mobile phone also. It is coming as a PDF. Download it, keep it. That's it. Correct. Smriti sort of gives a summary. Constructive notice and ultra vires read together, contract is void. Madam, constructive notice and ultra vires read together. See, ultra vires says contract is void. Constructive notice says you can't say I have not read it. You should have read it. You are deemed to have read it. Together, they make the contract void. The exception is indoor management, which says that you can only find out what has to be done. You cannot find out whether it has been done. That will take you indoor. Therefore, third party is protected so long as he has satisfied himself that what has to be done has indeed been done and that the contract is within the powers of the company. So this is how we have to understand it. Fantastic. I'm so happy that you are all able to do this such a beautifully. Moving on. Now we move on to the alteration, various kinds of alterations, like alteration of memorandum and articles. Now, we are going to use one word frequently in this for this special resolution or ordinary resolution talk. When you come to management and administration, they will teach you what it is. When you come to management and administration, they will teach you what it is, right? So, what is special resolution? Right now, I'm going to give you a simple definition. A resolution means approval by majority. Resolution means approval of the transaction by majority of the shareholders or members. Resolution means approval of a transaction by majority of members, majority. So if there are 5 people, 3 agree, 2 do not, majority, simple majority. So ordinary resolution is simple majority. Ordinary resolution is simple majority. 5 people are attending, 3 vote for, 2 against, resolution passed. 3:2, majority, simple majority. Number of votes cast in favor more than number of votes cast against, if any. Special resolution, slightly different. You have to be a little careful here. That's why that definition I'm not going now. If I go there, that is will take time, but quickly. Number of votes cast in favor should be 3 times number of votes cast against. Number of votes cast in favor should be 3 times number of votes cast against, if any. But then there is something more here. A lot of things are there. Notice should tell that it's special resolution. Members who are attending and voting only we have to consider. That is there. Broadly, ordinary resolution means approval of a matter by members. Okay, or board resolution by board, other than board resolution by members, right? So any approval by a majority of members is a resolution there. When an ordinary majority, simple majority is needed, it is ordinary resolution. When special majority is needed, there is the number of votes cast in favor should be 3 times the number of votes cast against, if any. Are you able to understand? Special resolution. See, 5 people attend, 3 people for, 1 abstaining, 1 not voting for or against, 1 against. Have I passed a special resolution? 5 people attend, 3 for, 1 abstaining, not interested, not, and 1 against. Now, what is special resolution? The number of votes cast in favor should be 3 times the number of votes cast against, if any. So 1 into 3, I'm reliably informed, is still 3. 1 into 3 is 3. Number of votes cast in favor is 3. So number of votes cast in favor is equal to 3 times, is not less than, 3 times, is equal to, is not less than, no. It's not less than 3 times the number of votes cast against. If you have not understood it, don't ask me to explain again. It will be explained in detail by the faculty who's teaching you management and administration. Right, sir? Clear now? Special resolution. But in the original example, 2 against, 3 for, special resolution not passed. Because number of votes cast against is 2. 2 into 3, unfortunately 6. Number of votes cast against is only 3. Therefore, the number of votes cast in favor is less than 3 times number of votes cast against. Therefore, special resolution not passed. In a nutshell, in very simple way, I have explained special resolution. Later on, when you come to management administration topic, the faculty who teaching will give you more detailed info. Okay, sir? Just this is meant because I can't just as a special resolution. So quickly I am putting a patch there. But don't question me or play games with me. The faculty who teaches that topic, management administration, will clearly explain to you what is special resolution, etc., etc. But try to remember this. Okay. Number of votes cast in favor should be not less than 3 times the number of votes cast against, if any. Maybe like Buddha, you have to be, remember this. Okay. Fine. So, alteration of memorandum requires special resolution. Any clause in the memorandum, you want to touch it, special resolution. Section 30. Similarly, subject to the provisions of the memorandum and the act, company may a special resolution alter its articles. So, alteration of articles by a special resolution. Alteration of memorandum special. But any alteration of articles should be subject to the provisions of act and conditions contained in the memorandum. Okay. But it's not as easy as we think it is. I don't know why these people are all coming now, waiting in the waiting room and asking me to admit. God only knows what's happening here. Okay. Anyway, so procedure for alteration of name. There are two things about name. One is alteration. The other is rectification. First, we are going to see alteration. Alteration means voluntary. Voluntarily, we want to alter. Voluntary. For that, you have to pass a special resolution for alteration of the memorandum. The name clause should be changed. Are you able to understand? Name clause should be amended. Then, since you are changing the name, you have to make an approval to the central government. In application to the central government in Form INC 24. Right, sir? In Form INC 24. As per Rule 29 of the Companies Incorporation rules, where mainly they will see whether you have violated any of the provisions of the Act, whether you have filed your annual return and financial statement and all that. Everything is clean, then they will say, go ahead. So, once the ROC, the central government approves your name, change of name, the registrar will enter the new name in the register in the place of the old name and issue a fresh certificate of incorporation. That's all. Procedure over. However, where you are only changing the name private by adding or removing the name private on conversion. So suppose private company is becoming public, private will be removed. Public is becoming private, private will be added. For that, there are other procedures. Therefore, you need not bother about it here. Conversion from private to public, public to private. I'm sure you'd have seen it in the types of companies and all. So you need not see it here. For that change in the name, you don't have to go for this. Okay. So this is a thing. Let me quickly see. I have a small example I can show you. Allow me to just. I used to give an example. It may be of some interest to you. Just give me 1 minute to open it. See, these are the forms for change of one of my own companies. This is not a client. I am not revealing any confidentiality. I am not violating any client confidentiality. This is a company in which my wife is a shareholder and director. Okay. It's a consulting company, Blue Dot Consulting Solutions. We changed the name from Blue Dot Consulting to Prometheus Consulting. So this is the certificate of incorporation issued by the registrar, okay, in 2022, April 2022. It was recently changed. For that, we have filed Form INC 24. Just showing you to show you. It's a stupid form here. There's nothing great about this. See, form and all, you and I as chartered accountant shouldn't waste our time. But still, as a matter of practical interest, I'm showing it to you. That's this form filling and all, you and I shouldn't be doing it. Yeah, we leave it to the other professionals whose job is that. Okay, let them do it. Okay, we just tell what to do. Idhar aao, udhar jao, kar, aisa karo. That's it. That is our role. Don't become form filers and paper pushers. No. So the board of directors had approved the proposal to change the name of the company, etc., etc. So this is some sort of a reason for changing the name. Okay. Actually, the reason is the name Prometheus was found to be suitable by us. Prometheus, if you don't know, for those of you who know your mythology, Greek mythology will know. Am I correct? Prometheus was the man who brought fire from the gods to the human beings. Prometheus was the man who brought light. For that, he was punished by Zeus, the king of the gods. He punished Prometheus. And one of the titans, Prometheus was one of the titans, but he was punished by Zeus. And he was imprisoned on a rock. And a vulture was kept nearby it will open his belly and eat his intestine. Slowly, one by one, it will eat his guts. What a painful thing. And finally, it will be, again in the evening, it will heal. Next day, again, the vulture will come and start doing it. And he'll be chained. Prometheus chained. But later on, I think Hercules comes and releases Prometheus from his prison. Anyway, point is, these are the information that you have to give and digitally sign it. And by one of the directors. That's it. Go. Now, later on, when you come to management and administration, you will study MGT 14. Whenever a company passes a special resolution and certain other resolutions, within 30 days, you have to file Form MGT 14. That is also, I'm showing you now, MGT 14. This I cannot upload it because all said and done, it's a private document. Okay. I'm showing it because it is my own company. Section of the Companies Act under which passed 13(1). Got it? No section we are now studying. Right? Okay. So these are all examples. See, one more thing you'll see here. The company, see, this particular meeting was held with shorter notice. That also you'll see. When you come to management administration, in case I'm teaching you, I'll show you. At this stage, no. I only want to show you for change of name. See, this is the resolution. Resolve that pursuant to Section 13 and other applicable provisions and subject to the approval of central government, consent of the shareholders be and is hereby given to change the name of the company from Blue Dot Consulting Solutions to Prometheus Consulting. Okay. So the existing clause 1 of the memorandum be hereby substituted. Are you able to understand? Wherever occurs in the memorandum and articles, the name will be changed. Are you able to understand? So this resolution is filed with the ministry. And right, just for your information. So this is the AGM notice. When you come to management administration, again we can go through it. At that time, we'll with more emphasis on meetings and resolutions. Proxy form. And it was done for a shorter notice. For that also, there can only 2 shareholders. So both of them have given their consent. See, all sorts of nonsense have to be done. Minutes, everything is here. Everything I can show you. Completely one whole meeting, how it is to be done for one subject. You can study from this document and you will know. Okay, so this is more for you to give you a better clarity. Don't Madam Ashish Kedia, Mr. Ashish Kedia, you're giving some very, very bad comment in the chat, sir. Mr. Ashish Kedia, you will have to move. What are you trying to put there? Sir, technical person, are you there? Sir, technical person, are you there? Please see the chat box. Ashish Kedia. Please see the chat box, sir. Hello. Please see the chat box, boss. Ashish Kedia. What is this, yeah? I'm Harleen Kaur. What is this? Please see the chat box, sir. Are you seeing it? One Ashish Kedia has put. I'm so sorry. I'm disgusted. I'm not going to. If this is how students are going to put comments and all, I can't. Hello? Hello? Sir, technical person, are you there? I refuse to continue. I'm not going to continue if this comment has come from Ashish Kedia. I want that student to be investigated. It's not only about, he is putting my name in it. That in that message, he has put my name and with vulgar and abusive words. It's not removed, it's there. I can still see that nonsense. And if that Ashish Kedia has to be first sent out of this meeting, please identify who that member is and send him out of the meeting now, immediately, if you're having control. I'm feeling very, very much upset about this. First time in my history of my teaching in this institute, such a thing has happened. I want investigation into that gentleman. Because this is a class of the Institute Board of Studies, yeah. Sir, who's the technical person, sir? Can you ask Nidhi or somebody is here? Can they have a look? Shraddha or Nidhi is there, they can have a look. In fact, I'm going to take a photograph of this. Actually, even that is, it's so vulgar. I cannot take. Who is this Ashish Kedia? And the lady students are there here. What is happening? No, if it's a fake ID, how did he get in? How did he come into the meeting at all? I'm so sorry. No, if this is Mr. Kedia's idea of fun, and if he's even trying to become a member of our institute, he should be prevented from becoming. Okay. Okay. Anyway, I'm very upset. You see, when I'm teaching something very serious subject, this type of comments are coming. Okay. Anyway, chalo, let us continue. But see, then don't use the chat box, sir. I will not see the chat box. But even if you sent it directly to me, this is not the way it does. It is correct, sir. Whoever is doing it, yeah, please, boss factor, please, Ms. Shraddha is here. Can you kindly make her a co-host? So, even assuming Ashish Kedia sent the message to me directly, I don't know how he can even enter and do this into our meeting. Is a direct message, no doubt. Ashish Kedia. Okay. I'm sorry. If this is how it's going to be, then I'm not interested here. Very, very bad here. Anyway. And please admit those who are entering and waiting here. That is also there. All sorts of problems are there in 400 class like this. Anyway. So, anyway, continuing with the session, we saw alteration. Okay. Be very, very careful. Very, very important. The change of name shall not be allowed to a company which has not filed annual returns or financial statements due for filing with the registrar, or which has failed to pay or repay matured deposits or debentures or interest thereon. I told you now, mainly they are concerned about filing annual return and financial statement. Also, to pay or repay matured deposits or debentures or interest thereon, right? The change of name shall be allowed upon filing necessary documents or payment or repayment of matured deposits or debentures. Okay, once they pay, then it will be allowed, right? So this is the thing. Now, we are going to look at rectification of name. Slightly different. Alteration is voluntary. I want to change procedure. Rectification is where my company's name resembles or is identical with the name of another company. It can be through inadvertence, means mistake, genuine mistake, or otherwise a company on its first registration or on its registration by a new name, it is registered by a name which is, in the opinion of the central government, identical with or too nearly resembles the name by which a company in existence had been previously registered. So, identical or too nearly resembles. Are you able to understand? Identical means same name or similar name, sounding similar. For example, I gave the example Sony. S-O-N-Y Sony is a famous Japanese brand. S-O-N-I Sony could be a local Indian name, Sony. It's one of the surnames in North India. But sounds similar, na? So Sony Corporation may object. So if it is identical or too nearly resembles with a company which has already been registered under this law or earlier law, then either this or, in the opinion of central government, is identical with or too nearly resembles an existing trademark. See, there may not be a company, but the name you have selected, like for example, Sony, is a trademark, well-known trademark. Therefore, the trademark holder can object. Either way, if the central government is of the opinion, then in the case of the application by a registered proprietor of a trademark, it has to be done within 3 years of incorporation or registration or change of name of the company. So if you are a trademark holder, you have to object within 3 years. Okay. So you have to mention that it resembles your trademark. With respect to identical with or too nearly resembles also, it has to be 3 years. Within 3 years, it has to be, application has to be made. If so, the central government will go through the matter and direct the company to change its name. So first level, that CG is satisfied that this company is doing. Then the CG may direct the company to change its name, right? And the company shall change its name or new name. Once CG directs it, the central government should change its name. The company should change its name within 3 months from the issue of the direction, after adopting an ordinary resolution for the purpose. So see, for the company to do something, you have to pass a resolution, the decision to be taken by the company. Therefore, you have to pass an ordinary resolution. So central government sends a direction within 3 months. Now, there is a larger question that I will ask logically. Boss, I am the board of directors. My name resembles. You have told me to change it. I will change it. But how you are telling me to pass an ordinary resolution? Now, be careful. For that, what I should do? I should hold a meeting. Right? At that meeting, majority should vote in favor. Suppose they don't vote, the resolution is not passed. What do I do? This is a bigger question. I've been raising it continuously, but they have given a solution later. Don't worry. In case the company does not pass an order resolution, now there is an option. Under the earlier law, there was no option. Now there is an option. Okay. So basically, they are saying, boss, you be a good boy. When the central government, there is the regional director, sends you a direction, obey. Hold a meeting, pass an ordinary resolution, change. Okay. The notice of change of name will be given to the ROC together with the order of the CG. ROC will make the change and give you the fresh certificate of incorporation. Now, in case if a company is in default in complying with the direction given as aforesaid, the central government will allot a new name. Thereupon, the registrar will enter the new name, and that's your name then onwards. That's all. So if you don't take the opportunity, doing it within 3 months, now central government has been given the power to do it for you. My only question is, why even give these people an opportunity? You give them an option to give a name. Once they give the name, that is, they're initially telling you yourself, choose a name, change it. If you don't do it, then I'll give you a name. Don't worry. So the company can always subsequently change its name, provided that it cannot go back to the earlier name. Okay. If there is any default in compliance with direction, in addition to that, the central government changing the name, the company can also the fine of 1,000 rupees for every day during which default continues, and fine to the officers of 5,000 rupees up to 1 lakh. Right? We have finished name. Now we move to registered office. Okay. Maybe I'll run another 5 minutes or maybe 10 minutes. Then I will stop for a small break. Once a company is incorporated, it is required to maintain a registered office. This is a physical office where the corporation will receive service of legal documents. Just like you have an official address, whenever you go for KYC to a bank, you give them address proof where you stay. Like that, company needs a KYC now. So this registered office, as you all remember, at the time of incorporation, I need not give the details. It is enough if I file the details of registered office within 30 days. Okay. This address cannot be a PO box. It must be a physical location. Unlike US, where corporates can have PO box addresses. Even individuals can have PO box. In US, the freedom of the citizen is very high. You can have PO box, which is very great advantage if you want to do illegal activities. They allow. For example, US that way, they are pioneering country. So guns are allowed. Most states permit you to have a gun with a license, of course. Every individual can. Here in India, you can't have a gun. Very costly, very difficult to get a license. But US, everybody and their brother-in-law will have a gun with a license. Okay. And you can have a PO box and all. The protection of the individual's freedom, very important there. Okay. Now, this address cannot be a PO box, but must be a physical location where someone is present to receive service of legal documents. It could be different from head office or corporate office. See, company can have for example, I give the example of a company incorporated in Indore. See, maybe in Indore, right? In the Bavra district, they got a factory and the promoters come from that district. So they started it there. It became very big and it started beyond MP, it started developing northern region full, then western region, then south also they are trying to go. So they are growing. Now at this stage, they set up a head office or corporate office in Mumbai because Mumbai is more centrally located, etc., etc. But still the registered office can continue to be in Bavra or Indore, in a slightly bigger city, but they need not move out of MP. Are you able to understand? We'll take this example and see all the options. So the domicile and the nationality of a company is determined by the place of its registered office. Also the jurisdiction. See, usually in civil suits, you have to file the suit where the defendant resides or the cause of action arises. Defendant resides. Suppose the Bavra company, if you want to file a suit, you have to file it in Bavra, not anywhere else. Why I know Bavra? Because I visited Bavra in Madhya Pradesh. I visited Mandu, Bavra, Maheshwar, and of course, Indore to that route I have gone on an audit. Completely I have traveled across that route. So I know that belt of Madhya Pradesh. That's why I'm telling Bavra. I stayed there in Bavra, 2 days I stayed in. From there, you go a little bit east, I think you come to Kataknath, where they have very famous Kataknath chicken and all. Okay, a company shall within 30 days of its incorporation and at all times thereafter have a registered office. You should inform the registrar about the location of the registered office address in Form INC 22. And notice of every change in the situation should also be informed within 30 days of the change, okay, to the registrar. The idea is, anytime we should know where to come and catch the company. Also, the name should be fixed, painted and affixed on the outside of every office or place of business. It should be engraved in legible characters on its seal, even on letterheads, promissory note, hundi, check, everywhere. The name should be given clearly. SIN also should be given. Next time you see the letterhead of a company, ensure whether all these are there. SIN should be there. Telephone number, fax, email, website address should be there on all its letterheads, billhead, letters, papers. Check it out because otherwise it will be a violation of Section 12. Where a company has changed its name, it shall paint or affix along with its name the former name or names. Okay. The registrar has reasonable cause to believe that the company is not carrying on any business or operations. He may come for a physical verification. In case there is any default, then penalty of 1,000 rupees. Okay, and for officer 1,000 up to 1 lakh. But I've been using the word registrar. When we say registrar, we always mean registrar of companies, ROC. As we already know, 2 states in India have 2 ROCs. Maharashtra and Tamil Nadu have 2 ROCs. All other states have only 1 ROC. Right? No. Change in registered office. Change in registered office, you have to be. I'm going to classify it under 4 broad headings. Within the local limits of the same city, town, or village where such office is situated. Bavra district, there in Bavra. Okay. Azad was born there in Bavra. Chandrasekhar Azad was born there. Okay. So or maybe I'm wrong. If you're from MP, you can correct me in that place, right? So within the local limits of the same city, town, or village where such office is situated. You want to just change it from one location to another, from this street to that street, from this neighborhood to that neighborhood, same city, town, or village. No problem. Just file board resolution, give notice within 30 days in Form INC 22. No problem. Right, sir. You are moving from the local limits of any city, town, or village where such office is situated, right? From outside the local limits. For example, as I gave the example, the factory is in Bavra, the register office, sentimentally they were in Bavra, but 3 generations down the line, Bavra is not, we would prefer to go to Indore. They all moved to Indore. They have built huge palatial bungalows in Indore. So their one office is in Indore. The main coordinating office is in Indore, but still registered office is factory. So they are saying, no, Baba, let's go to Indore. So they decided to move the registered office from Bhavra to Indore. Same state, same ROC, still, because you're moving from outside the city, town, or village, you have to pass a special resolution. Outside CTV, you have to pass a special resolution. Again, you have to give notice to ROC, etc., etc. There is no alteration of memorandum. In these two examples, no alteration of memorandum, because memorandum will contain only state. You are still in Madhya Pradesh. You are not moved. Okay. Now, next. From the jurisdiction of one registrar to another registrar. See, this is possible only in Maharashtra and Tamil Nadu, where there are 2 registrars in the same state. That's why I'm telling 2. For example, we'll be seeing Adekar Industries. In fact, that case study I'll be giving regularly in my classes. Adekar Industries started in Pune. So, because Mr. Vijay Adekar is from Pune, therefore it starts in Pune. Now, that Adekar Industries, it's a fictitious company. There is no such company called Adekar Industries. There, it is a Maharashtrian name, Marathi name, but there is no such company called Adekar Industries. But assuming that such a company is there, it has its registered office in Pune. Now, they want to move to Mumbai. So, from one registrar to another registrar. Are you able to understand? Therefore, they have to make an application to the regional director. See, all the ROCs come under the regional director. Obviously, in this case, the Western Regional Director, RD West, who will be sitting in Mumbai. So you have to apply to the RD. Okay? And then communication, then you have to get his confirmation. Then whatever confirmation received from RD, you have to file it with the registrar. That is, sorry, the RD will send the confirmation to the registrars. To the company. Then the company will file the confirmation with the registrar. So RD should give his confirmation and send it to the company within 30 days from the receipt of application by the RD. Very time bound. Of course, what he will do, he will not refuse to give. He will raise 15 questions and send it back to you. You have to answer all the queries. But if you answer all the queries, then finally he has to confirm it. And then after confirming it, you will have to file it to the ROC. Then Pune ROC, the ROC who is holding your file will transfer it to the other ROC. And the Mumbai ROC will register and certify the registration. Okay. So the certificate above will be a conclusive evidence that all the requirements have been complied. So this is only movement from one ROC to another ROC. RD can do it. Suppose, finally, ultimate, our example of, come back to my Bavra company. Bavra to Indore we have come. Now Indore say, Mumbai, we are a big company now. We are going public. Maybe they went public. So before going public, they want to move to Mumbai. They want to have a huge corporate office in Mumbai. So they moved there. That corporate office, they want to make it registered office. Done, sir. You can do it. For that, the procedure is, now for the first time, remember, there is a change in the memorandum. The memorandum will now be altered. The situation clause. So you have to pass a special resolution for alteration of memorandum. Please note, you should also pass an alteration for special resolution for moving it outside the city, town, or village. Am I correct? You're now moving it out of Indore to Mumbai. For that also, you have to pass a special resolution. Plus, you have to pass a special resolution for changing the situation clause. Then you have to file an application to the RD. The central government will find out everything and then it will pass a 60 days. Then the company will file an order of the RD with the approving the alteration with the ROC of each state. And so that is, if you're going to Mumbai, then Western region RD will fine. Even say if you're coming from south to north also, whichever place you are going, that RD should approve. Suppose you are moving a company from Chennai to Mumbai, which it incidentally happened. You have to file with the RD West. Then the RD West will communicate with South and take the file. Okay. And both the ROCs will register the same. And the ROC of destination state, that is Madhya Pradesh ROC. I'm sorry, Mumbai ROC will issue fresh certificate of incorporation. So everything will be done by the Mumbai ROC, the destination ROC. Okay. Once he instructs him, this file will go to the destination. Any negatives are there, before it leaves, they will take this. Okay. See, earlier, alteration of situation was very complicated. You have to go to court and all, or then you have to go to tribunal. Now they have simplified it. It is all done by RD himself. Any other alteration of any other clause, it is enough if you pass a special resolution and you should register with the registrar of companies. MGD 14 you file, that's all. Once you file the MGD 14, it will be registered. Okay. Now, in case a company has raised money from public through prospectus, in case the company has raised money from public through prospectus and has any amount unutilized, now that company shall not change its object. Such company shall not change their objects for which they raised money through prospectus unless special resolution for this purpose through postal ballot is passed by the company. I have to understand. This is in addition to object clause you amend, no problem. But in addition to that, you have to pass a special resolution for changing the object. Special resolution. And you have to circulate it to all the members in a newspaper. Now, let us say that you have passed a special resolution, sir, for alteration of object clause. But still, if there are any dissenting shareholders, meaning, see, let's put it this way. You took money from me in the public issue. I gave. You used some of it for the project. Then some surplus was there. You are now saying I'm going to use it for some other project, some other activity, amending the memorandum. Now you want to be careful about ultra vires. So you're saying I'll amend the memorandum and then only I'll use it. So you come to us for amendment of memorandum, special resolution. But I am not happy. I came for the meeting, I voted against. But since majority didn't mind, you decided to proceed with that object. No, I don't want. I want to get out. I am a dissenting shareholder. I should be given an opportunity to exit by the promoters as per the rules made by SEBI. Means either the company should buy back or the shareholders should buy. The idea is to protect the investors who have invested their money based on the original object. So this is an extraordinary example of investor protection. It's a proactive one of the, see, normally I will be shouting at the 2013 Act. I'll be commenting about the language, grammar, very bad usage of English and all. But this one provision, I'm happy. It protects the investor and it puts a threat on companies trying to take money from investor and misuse it. So in relation to alteration of memorandum, once a special resolution is passed, you have to inform the registrar within 30 days. Okay. And it should be registered. Means the ROC will register it and give you a memorandum of registration. You bring it and that's it. See, you already saw this when you studied, I'm sure, memorandum, we saw this. We said that for a company limited by guarantee not having share capital, you cannot share the profits with a non-member other than a member. So the memorandum also cannot be altered so as to provide for payment of dividend or any sharing of divisible profits to the non-member. So memorandum cannot be altered to do this. Original memorandum cannot contain. You cannot alter the memorandum also to do this. That's what they are trying to say. They covered it there. Then they thought, oh, maybe if these fellows alter, what to do? They said even alteration will be wide. articles alteration basically requires special resolution, normal alterations, but one special alteration, you have to be careful. See, I'm so sorry, 1 second. Really? Here. Here. Okay. I was thinking some words are there in there. Okay. So any alteration having the effect of conversion of a public company into a private company shall not be valid unless it is approved by an order of the central government. So private becoming public, we have no problem. Welcome, welcome, welcome. But you just amend your articles and come. But public becoming private, wait. What are you doing? Are you trying to escape some offenses? So we will go through it carefully and find out whether the public company has committed any offenses in trying to run away and becoming a private company. So before a public company means what? When a public company wants to become a private company, they will include the three matters. Do you remember? The restriction on transfer of shares, prohibition on invitation to public, limitation on number of members. These three will be included. Further, they have to amend the articles. Now, that alteration will not take effect unless it is approved by the central government. So, if you want to convert private to public, no problem. Pass a special resolution, file an application to the RD in E-form number RD1 within 60 days of passing of special resolution, file memorandum, articles, minutes, board meeting, etc. And if they no longer include the restrictions, that's all. Once you file this RD1, with that your company will now become public. Absolutely no, they will not delay the approval and all. Within 60 days, you file all this. Immediately they'll say, welcome, come. Because they want, now you're later now. So they're happy. But if you want to go reverse, it will take time. The reverse, where you're removing it. With the public company, you are adding it. Then there will be a little more. Okay. Every alteration of articles and a copy of the order of the central government approving the alteration for conversion shall be filed with the registrar within 15 days. Okay. And any alteration will be valid as if originally contained in the AOA. Okay. You have to make the change. Whatever you have made in the articles the change should be noted in every copy of memorandum articles. Okay. Or reprint it. If a company makes any default in complying with the stated provisions, the company, every officer will be liable for 1,000 rupees for every copy of memorandum issued without the alteration. Any member is entitled to a copy of the memorandum and articles. Okay. Anyway, before we go into this, I will go for a, shall we say, a small break. I think you are all afraid to put anything in the chat. Friends, absolutely no problem if you put questions in the chat. Yeah, I'm more than happy to take. Some donkey has come and done this. Yeah. Thank you, Ms. Supriya, for sort of giving your sympathy. Anyway, feel free to raise questions, etc. In fact, time permitting, because we have time till 8:30 today, I will be taking up some questions also, some assignment type of questions, which are there uploaded. With the answers I've uploaded, I will take it up now and we'll try to answer them also. Okay, so that your appreciation of practical situation also will go. For this, it's going to be very, very less. Another maximum 11 slides and then we are done with it. So thanks to your cooperation. In the meantime, If you have any queries, you can ask. The time now is 7:40. Allow me to take a break for 10 minutes, right? Maximum. The time now is 7:40 per my mobile. Allow me to take a break till for 10 minutes. Sir, short break for 10 minutes, sir. Thank you. Welcome back from your well-deserved break. So it's from now on, it's downhill. We are going to come to the end of this topic. Most of it is procedural, not very important also, I would say, but it's not fair that we should not cover it. So as a matter of propriety, I will cover this also. So basically, as a member of a company, you are entitled to copy of memorandum and articles, etc. Because today nobody will go and ask the company, because if you want memorandum articles, it's available in the computer, in the company MCA website. Just go and download it. But still, if you want the company to give, you can ask for it. And the company should send it within 7 days on payment of fees. So memorandum and articles. Every agreement and every resolution which are to be filed, okay, like MGT 614, I showed you, no? All that also they have to give you. MGT 14, when you come to section 117 in management and administration, you will see many resolutions and agreements are to be done. So in those cases, you will do that, right? So if you have any queries, kindly put them up in the chat also if you want, or in the query pad, whatever you want. In case genuine queries related to subject can be put in the chat or in the query. So in case of default, the company and every officer who is in default shall be liable for a penalty of 1,000 rupees for each day during which the default continues, or 1 lakh, whichever is less. Right. Now, in case you do not comply with the provisions relating to commencement of business, you remember, within 30 days, you should ensure that the money is brought in and registered office of the company is filed. Remember? And so this condition, if it is not satisfied, then, and the declaration is not filed within 180 days, the registrar has reasonable cause to believe that the company is not carrying on any business. Then, without prejudice, we already saw the penal provisions. They can initiate action for the removal of the name of the company from the register of companies. Very serious. Later on, when you come to final, you will see strike off of name. One of the grounds for strike off is where the company has not commenced business. The company has failed to commence business, the name of the company can be struck off. In case some of you would like to know what is the meaning of the word without prejudice, I have given here what is the meaning of the word without prejudice. In addition to, that is, there will be penalty. In addition to penalty, without prejudice to penalty, it's also. You see, conversion of private public, we have seen. OPC to private, we have seen. OPC to public. Am I correct? Sorry, OPC to private. Private or public to OPC, we have seen. Now, any class already registered from one class to another class, you have to alter a memorandum and you have to apply to the registrar and get it approved. Okay, and he will issue a fresh certificate of. Once a company has changed from one class to another class, there will be no change in the debt, liability, obligation, etc. Okay, but whoever was a debtor will continue to be a debtor here also. That everything will be continuing as it is. See, even when a private company converts into a public company, public into private, the debtor creditor will not change. As a matter of courtesy, we will inform them once that the company is now a private company, public company. Only today, one of my clients, who's been our client for 45 years, 40 years, our firm is 50 years old, client has been with us for 40 years, and the client is a 60-year-old company. That company has converted now, just today only, from private to public. Today only they converted from private to public. It means today they got the certificate of incorporation as a public company. The process was going on. Today only they got. So, if so, then as a matter of courtesy, we will write to all the debtors and creditors and other people that we are now changed. Very important. See, no company should hold either itself or through nominees in its holding company. See, you already seen subsidiary and holding, I hope, in the definitions preliminary part. So there is a holding company, there is a subsidiary. Obviously, the holding company will hold shares in subsidiary, but subsidiary cannot hold shares in holding company. Holding company will hold in subsidiary. That is how they become holding company. But subsidiary cannot. Okay. Cross holding is not possible. HC in CSC, SC in HC. No holding company shall allot or transfer its shares to any of its subsidiary companies, and any such allotment or transfer is void. So, subsidiary should not hold shares in the holding company. Notable exception. Notable. I already mentioned now. If at all in law there is a rule, there will be an exception. Okay. Where the subsidiary company hold such shares as the legal representative of a deceased member of the holding company or as a trustee. See, rare cases, man. There is a member who got deceased. His share is now being held by this holding subsidiary company as a legal representative or trustee. Very rare case. The other possibility is there, where the subsidiary company is a shareholder, even before it became a subsidiary. This is where, see, in the exam, if I want to really irritate you, I'll set a question here. You know what I will say? Holding company, or rather, I will say MEF Limited, MEF Private Limited is currently holding shares in DEF Limited. Is currently holding 1 million worth shares in DEF or 1 lakh worth shares in DEF Limited. Subsequently, on some such and such a day, DEF Limited acquired stake, 51%, 60% stake in MEF, thereby becoming its holding company. Okay. Comment whether the holding of shares by MEF in DEF after the becoming its subsidiary is valid. Are you able to understand? Now you should say, normally a subsidiary should not hold. No company shall either by itself or through its nominee hold any shares. No holding company shall allot a transfer. But one of the exception is where the subsidiary company is a shareholder even before it became a subsidiary. Then you clearly mention the name, dates. The MEF became a subsidiary on such and such a date. Shares are being held by it from such and such a date, but before that. Therefore, it is valid. If you write an answer like this, you get full marks. Okay. So in this case, shares of a holding company, which is a company limited by guarantee or an unlimited company, not having share capital, shall be construed as a reference to the interest of its members, whatever be the form of interest. Now we move on to some definition in the Companies Act. Document is defined. We already seen it in preliminary. I'm just giving it here as a reference because we're going to see the word document. Okay, that's why I'm defined. The word is defined in this act itself. See, the word document is defined here. The word document is defined in Transfer of Property Act. The word document is defined in General Classes Act. When you come to General Classes Act, again we will discuss document. I mean, we or whoever faculty will teach, they will talk about document. Okay. So, serving of document to company. A document is anything, boss, a summons, notice, requisition, order, declaration, form, register, whether issued, sent or kept in pursuance of this act or under any other law for the time being, whether maintained in paper or in electronic form. So whatever it is, if you want to serve a document on a company, serve means what? Ensure that it reaches the company. Then you can send it by registered post or speed post or courier service, or you can leave it at the registered office of the company. Leaving means just come there there will be a receiving section. Go there and deposit it. Take a snapshot and look and go. You personally, the member can come and do, or person can come and do. Send it by registered post, speed post, courier. Okay. Right. However, where securities are held with a depository, the records of the beneficial ownership may be served by such depository on the company by means of electronic or other means. In the case of shares held with a depository, then see, simple was when you buy shares, the depository, the CDSL or NSDL, they will inform the depository that is the depository will come to know about it from the stock exchange, right? Continuously. Then the depository, through its DP, they will not inform the company by letter. Every day, boss, millions of transactions. So what they will do is they will send an electronic message, electronic mode. I'm not joking. Yes. I have done the audit of the share transfer department of large companies. Some large companies, they do their own share transfer. They don't have an agent. And as part of the SEBI norms, they have to have an IS audit, information systems audit. As an IS auditor, I have done it. You will find that there are two leased lines from CDSL and NSDL. Leased line, which cannot be hacked, nothing can be done. Very powerful. And every day, the data will flow from the depository to the company through these two lines. In the company is employing a share transfer agent, then through the agent, they will get it. Whatever it is, thereafter the application for transfer of shares, that will take over. And the data will be used to update the members register. So that at the end of every day, the members register will be updated. So today, with volume of transactions, it is not possible to do it by post. That is what they are saying, where the shares are held with the depository, the records of beneficial ownership. That is, that I have now become the beneficial owner of shares of Lupin Limited, Lupin Pharma. Agreed. That will be informed through the electronic mode. Right. If you want to serve document to registrar or member, this is serving document to company. You are now serving registrar or member. You can send it by post or registered post or speed post, courier, etc. by delivering at his office or electronic mode. Okay. Now, please note, if you are having a DP account, then your registered email ID is the only way in which a listed company will communicate with you. I'm being very clear here. No post, nothing. Your email address, you will get a mail. That is all. For example, AGM notice will be sent to that email address. E-voting form sent to that email address, which is registered with your depository participant, DP account. For all intents and purposes, that is your official communication. That to be very, very careful. Okay. In case a member requires through registered post or what, some special means, then he can get it, but he has to reimburse or pay the fees for the special mode. Okay. In the case of a Nidhi company, say one important quality of a Nidhi company is it's a small neighborhood activity where the members are all known to each other and will come from a similar area, and only members will deposit money, members will borrow. So it is a very closed operation. This is why Nidhis are given exemptions. Of course, these exemptions were misused in 1990s by certain unscrupulous people. Therefore, Nidhi companies are now suffering. All of them are suffering. But otherwise, it's a wonderful way of collecting, savings and lending to local businesses. That is the idea. So this is what you should understand is Nidhi companies are basically in lending and borrowing and lending. They accept deposits from the members who are basically from the local area, and then they lend it to the local traders and businessmen. So it's a wonderful way of generating local funding. Today you're talking about crowdfunding nonsense. In those days, we had all that. The local population, they generated funds, gave it as deposit, and the Nidhi company gave it to the trader. Okay, so this was wonderful. Before banking, before public sector banks, Nidhis were doing a great job of helping traders. Of course, certain weaknesses were there, but still, Nidhi companies were doing a good job. Now, a Nidhi company, if there is any document to be served on members, they can always put it for members who hold shares of more than 1,000 in face value or more than 1%, they have to send it. Other shareholders less than 1% or less than 1,000 face value, it is enough if you put a public notice in the newspaper and also affix it on the notice board of the Nidhi. That's all. Where something is to be authenticated by a company, then it can be signed by a KMP. KMP you already seen in preliminary. Who are all the KMPs? Full-time director, managing director, company secretary, CFO, CEO, any other person interested with any specific task or any duty by the board. These are the key managerial personnel, or an officer or employee of the company duly authorized by the board in this behalf, right? For example, certain documents of banks, including loan agreements and all, can be signed by an officer. Different levels, scale 3, scale 4, they have different signing powers. Sanction letters can be signed by them. So, a bill of exchange, hundi, or promissory note shall be deemed to have been made, accepted, or drawn or endorsed on behalf of a company if made, accepted, drawn, or endorsed in the name or on behalf of a company. Okay. So a deed signed by such attorney on behalf of the company shall bind the company. So once you say for and on behalf of, that's it. Okay. Bill of exchanges, etc. There are two categories. See, today under the Companies Act, common seal is not compulsory. A company need not have a common seal. But suppose the common seal is a kind of a stamp which is embossed on a paper. You have a stamping machine by which you emboss the company's seal on the paper. Now, common seal is not compulsory. If the company has a common seal, then it may authorize any person as its attorney. Under that is, the common seal will be affixed. See, the affixation of the common seal will be witnessed by 2 directors, right? If it is not having a common seal, then 2 directors can sign. Or where the company has a company secretary, 1 director and 1 company secretary can sign. So this is as I told you, the end of our topic. Now, since we have some more time and I can do something else, I will see if any queries are there. If any queries are there, we will take it. Otherwise, I will go for one assignment, one set of assignments. I've given you 2 assignments. No more queries are there in the query pad. I don't know why. Maybe the topic is fairly simple, so no queries. And okay, so let's see. Yeah, I will take up one. Am I correct? One of the assignments. Quickly, we have another 20 minutes. I can definitely do this. Yeah. So, Malfeasance Limited. The name itself is like almost like Dubakur Limited. Malfeasance Limited was incorporated by Mr. Unscrupulous and others. The company was formed for a fraudulent purpose by furnishing false information regarding the identity of the subscribers to the memorandum. Now, which of the following is not a power available to the tribunal when dealing with the matter on an application? Okay. Direction that the liability of the... So, do you remember we had a slide when I showed you? Direction that the liability of the member shall be unlimited. Direction for removal of name of the company. Action under section 447. Passing an order for winding up. In case you want to give answers, you can, but check it out because I'm not having time. Sometimes, in my class, they used to give. See, liability of members can be made unlimited. Removal of the name, yes, passing of an order, but 447 is not a criteria. We have seen this slide separately when I taught you. Okay. Now moving on to the next one, which is quite interesting. See, Rajdeep Industries was promoted by brothers Rajesh, Rupesh, Hitesh, Bhupesh, and 3 others. So totally 7. Rajesh, Bhupesh, Rupesh, Hitesh, Bhupesh, and 3 others. Totally 7. In 2017, the company operated from Ahmedabad, and Bhupesh, the youngest brother, was working in Muscat and was not aware of the affairs of the company. Are you able to understand? So he was in Muscat. He's not aware, but how can he be not aware that his one elder brother has died here? But assuming that he was not aware. Now this is the point. You cannot question. He was not aware. That's all. Okay. Now, Rupesh died on 15/7/2020. Right? Rupesh died on 15/7/2020. Eldest brother. Sorry, one of the second eldest brother. Rupesh died on 15/7/2020. Now, Rajesh, Hitesh, and the other 3 members, except Rupesh, because Bhupesh is in Muscat. So, in the meantime, Rajesh, Hitesh, and the other three, 5 of them together, they started running the company. Okay. 15/7/2020 onwards, they were running the company with a reduced number till 30/4/2021. They were mismanaging the company, useless fellows. And the company went into winding up. So at that time, the debts incurred, we have analyzed, they are as follows. Debts incurred as on 14/7, that is 14/7 balance sheet also, they were there. Now also they are there. Are you able to understand? On 14/7, they were debts. Today also they are due 2 crores. After 14, that is from 15/7 to 14/1. Now, what is the significance? We will see. Why this separately this is given? That is 1.5 crores. And after the 14/1 till 34, 40 lakhs. Now, Mr. Shiju, a creditor, who lent rupees 1 crore to the company on 15/12. 15/12, that is between 15/7 and 14/1. 15/12/2020, and rupees 40 on 15/1/2020. That is between 14/1 and 34. This is that 40 lakhs. Now he wants to know if he can sue the members and attach their personal assets. Can he do it? Now, if you remember, when the number of members falls below the statutory minimum, so for a public company, the statutory minimum is 7. When Mr. Rupesh died, the number fell to 6. Am I correct? Now, Rajesh, Hitesh, and the other 3 members, knowing that the number is so reduced, have run the company. So, if they continue to run it with the reduced number knowingly for 6 months, so that is 15/7 to 14/1, then they will become personally liable for any debt incurred by the company beyond the period of 6 months, not to 6 months. So, and in this Bhupesh, okay, was never informed about this whole matter. And Bhupesh was not, maybe he had a fight and he went, whatever, yeah. And so he was not on talking terms with Rupesh. No. So they never told him about Rupesh death, or maybe they told him about Rupesh death, but they didn't tell him about running the company with a reduced number. Maybe he's aware of Rupesh death. He came in July 2020. Then he went away. At that time, maybe even he told, was 6 months you have to check. So then they have not informed him that this company is being run with a reduced number. So Bhupesh in Muscat is not aware, but the other 5 are well aware. So those members who are running the company and who are aware will become personally liable. So Shiju can file a suit against any one of the remaining members except Mr. Bhupesh for 40 lakhs. The remaining 1 crore will be added to the list of liabilities. See, total liability is 2 plus 1.5. That 1.5 includes Shiju also. So 3.5. That he has to prove in the winding up of the company. But this 40 lakhs, he can sue these 5 guys. But even then he cannot sue Bhupesh because Bhupesh was not aware. Are you able to understand? So this is the type of question that will come in the examination. Similar questions could come, where they will give you some data and then they will ask you to apply the law. MCQ will not come. Here for convenience, I've given MCQ, but normally MCQ will not come. You have to actually write like this, according to section 3A. The remaining beyond the period of 6 months after the rate of reduction, membership below statute shall be severally sued. If you want, you can break it up. If you can't write such a long English sentence, no problem. You can say company where a number of members of a company falls below statutory minimum. The company continues to be run beyond a period of 6 months knowingly. Then the members who knowingly run the company beyond 6 months are personally liable. In the instant case, Bhupesh is not a director and was never aware that the company was being run with everything. Why he was not a director is stressed because director cannot say I was not aware, but a normal member may not be aware that this is okay. So this is one thing you mean. Similarly, Mr. Mukesh Lunkad, a person of Indian origin and currently a citizen of the United States of America, wants to form a OPC. Okay, Mr. Mukesh plans to visit India regularly and spend time with his parents in Junjunu. So Rajasthan, which is his place of birth, for at least 150 days in a year. So more than 120 days is going to stay. Can he do so? Now, this is where, in the exam, if you are not cautious, you will be misled. You will think that you are Yeah, Mukesh, come. You're coming to Junjunu. You're such a good boy. 150 days. Sorry, be careful. The crucial point, very, very important, what you should understand is man has become a citizen of United States, right? He has become a citizen of the United States. So he cannot, citizen, only natural persons who are citizens of India can become member of OPC. Merely because he's going to stay in 150 days, no. Let him surrender, see, he was citizen, come here. Okay. Mukesh Lunkat cannot form an OPC as he is not a citizen of India. OPC only citizen of India. Are you able to understand? Miss Lekha and Miss Rekha are twin sisters and are currently citizens of India. Wow, that's great. But they are pursuing their masters in science from Stanford University in the USA. They are proposing to start OPC in India, wherein they would be the sole members. Great. So they are both citizens of India. Wonderful. Let's see what the problem is. Now they need to appoint a nominee. Ms. Lekha, who is going steady with Mr. Sudhanshu Gupta, an Indian citizen, who is a senior at Stanford. She wants to nominate him as the alternative member, as a nominee. Rekha is proposing to appoint Dr. Rob. She is not going steady with Dr. Robert. It's just that he is a professor. Dr. Robert McDonnell. He is a professor and mentor. So don't confuse. Sudhanshu is a going steady, but Robert McDonnell, no. A professor and mentor, a US citizen. So she wants him to be. But sorry, Lekha, okay, Rekha, no. Because McDonnell can be appointed as a learner because he's a learned professor. Gupta, a student, cannot be appointed. No, sorry, that has nothing to do with the law. Gupta is a citizen, he can be appointed. McDonnell, not a citizen, cannot be appointed as a nominee. Right? Also remember, this is nothing to do with this problem, but keep in mind one more point. A person can be a nominee in only one company. A person can be a member only in one OPC. That is also sometimes they may test you that also. OPC is a private company. Am I correct? Okay. So this was long ago in my earlier session. I put this. Okay. So since I didn't have time in that VCC, I could not cover it. But now I'm having enough and more time. So I'm covering it. I think on the whole, we have done justice to the topic. I'm seeing some questions in the chat. Beautiful. So people are putting the answer. Yeah, Bhumika, that is the problem. He is not aware. That's all. You have to take it as how he is unaware. Wonderful. You also passed a special resolution. No, it's not visible to us. Okay. That is good. Fantastic. So there is no more queries in the chat box. Great. So let's call it a day. I'll just see the query pad. If you have no other questions, I would like to. Yeah. In section 3A, if members are not aware. Yeah. Any member who is not aware is protected. But if with knowledge you continue to run, you are not. Okay, before we conclude, Pawan Sharma sends a very important message. Let's see. Just to read something from, just like, when nonsense happened, one good thing also, Pawan Sharma is just coming live to my class. He has never attended my class live. First time he is attending live, Pawan Sharma. Pawan Sharma ji, thank you for attending. And I hope you like this. And he cleared his group 1 in first attempt by taking, because he downloaded my classes. And the beauty is, he's 38-year-old and working as an accountant. In spite of that, due to time limitation, he watched the video while driving from office and home, half hour one side. And he read only one time in office break and one time in house. He read the book. No written practice, but he took the MTP. Okay. And he wrote 2 to 5 hours morning, 1.5 hours in the evening, and he has cleared the exam in first attempt. We congratulate Pawan Sharma. And we are also inspired by his dedication to the course, and we wish him all the very best in his future undertaking. He has got secured account 69, law 46, taxation 54. Given his preparation of half an hour, he got very good marks, I would say. I congratulate him. Okay. Thank you, Pavanji, for your thing. And he also says that he loved my spiritual talk. Yeah, sometimes, unfortunately, I do give unnecessary spiritual suggestions to you. Take it in the right spirit. And thank you, Kesapuram Kumari from Southern Region. Thanks me. And wishing you all the very best. In case I don't meet you again in this session, bye, and wishing you all the very best for your examination. Yes, Astaji, absolutely correct. A person can be a member in one company, a nominee in another company. But he cannot be member in two companies or nominee in two. He can be in member one, nominee in another. Same, he cannot be nominee now in some other. But in one more company, he cannot be nominee. In one more company, he cannot be a member. Fantastic. So thank you very much for your wonderful interaction at the end of this session. Thank you. So yeah. I also passed special resolution. I showed you now MGT 14. Yes, I showed you now, Dhanushji. MGT 14 was filed. We filed a special resolution. I think I showed you. Special resolution was passed. See here. This is this INC 24. Also, we have filed MGT 14. MGT 14. MGT 14. MGT 14 is filed whenever we pass a special resolution. So can you see? Registration of specials. Whenever we pass a special resolution, we file it. And also see the notice, see the meeting. In the resolution, we have mentioned now to consider and if thought fit to pass with or without modification the following resolution as a special resolution. So absolutely, we have passed a special resolution. Fantastic. Thank you, Mr. Anubhav, all of you for your wonderful thing. Thank you. So thank you very much. I'm stopping the share and I am now going to end the session. Sir, class over, sir? Yeah, done, sir. Yeah.